Your Honor, I'm Mark Williamson. I represent the movement today, Taylor Shea, the father of the child.
Thank you.
I'm Vicky Shea. I'm representing myself.
All right.
I'm McKenna Isbell, and I represent myself.
All right. Would all those who intend to testify, please raise your right hands and remove yourself off of mute. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
Yes, ma'am.
Thank you. You all may lower your hands. So we are here today on a motion to set aside a void judgment. I do have some exhibits that were pre-admitted, and we're going to go ahead and admit those now. So Miss Vicky Shea's exhibits A and B are admitted, and Mr. Taylor Shea's exhibits fathers F1, 2, 3, and 4 are admitted. All right, so we're going to take some testimony. It looks like an order in a suit affecting the parent-child relationship was entered by the court back on August the 24th of 2021. And there was a motion to set aside the judgment declaring that order void because at the time that the order was signed, the case had already been dismissed. Is that correct?
Well, the challenge today is to the personal jurisdiction over Mr. Shea and what the court just mentioned, which is a technicality, order of pleadings issue. So to be clear, there's the issue of...
This hearing begins with formal introductions, but it quickly becomes clear this is not routine. The court is addressing a motion to set aside a judgment that may never have been valid in the first place. At issue is an order signed in 2021, years after the underlying case had already been dismissed. The father, represented by counsel, challenges the court's authority to have entered that order at all. Across from him, parties representing themselves struggle to respond within strict legal boundaries. From the outset, this hearing centers on jurisdiction, due process, and whether the law was followed.
Can one amend their pleadings after their case has been dismissed, and would an amended pleading that's not properly before the court support any order? Our position is no. But secondly, the order should be declared void for lack of personal jurisdiction on my client due to lack of service of process, no waiver of citation, no court appearance, general appearance by my client, and the fact that he didn't sign the purported order that was entered back in 2021.
Okay.
Without those, it's our position that without jurisdiction, the court could not have entered that order.
Okay. Thank you, counsel. Let's see. Ms. Shea, did you want to go ahead and, because all you all are doing, you're giving argument of why the court should maintain this order.
It should stay maintained. He lived in my house in August 2021 because we are taking him back and forth to work.
Your Honor, for the record, I need to object. Can I share my screen?
Yes, go ahead.
Your Honor, and while I'm doing that, I'd ask the court to take judicial notice of the contents of the...
As testimony begins, the legal foundation of the case comes sharply into focus. The father's attorney explains two central arguments. First, that pleadings were amended after the case had already been dismissed, and second, that the court lacked personal jurisdiction over his client. No service, no waiver, no appearance, and no signature on the order. These are not technicalities. They are constitutional requirements. Without jurisdiction, a court cannot act. The judge listens carefully, recognizing that if these claims are accurate, the order in question was void from the moment it was signed.
Kirk Baggett is qualified and certified by the American Institute of Applied Science and the American Bureau of Document Examiners, correct?
Yes, sir.
And we asked him to compare the purported signature on this agreed order to your signature on Exhibit 2, and we asked for his opinion, right?
Yes, sir.
And his opinion was that the signature on the order was indeed forged, correct?
Yes, sir.
I'll pass the witness.
Okay. Ms. Shea, this is your opportunity to ask any questions of Mr. Shea based on his testimony that he just gave.
Well, Mr. Shea, on the paper I got served, why is your signature different than the one that's on the screen? They're two different signatures.
It's not my signature.
The papers I got served in August has a different signature than the signature you have on that screen that's saying that's your original signature that is in green.
Can you pull the original?
This is Exhibit A.
When Ms. Shea attempts to defend the order, the difficulty of self-representation becomes evident. She speaks about circumstances surrounding the father's living arrangements, but repeatedly runs into objections. The judge sustains those objections, explaining that facts outside the pleadings cannot be considered. This moment highlights a critical courtroom reality. Intent and belief do not override procedural law. The court patiently redirects her, clarifying that the issue is not what happened in 2021, but whether the court legally had authority to act. The emotional frustration contrasts sharply with the rigid structure of legal rules.
That I got served with. That is
Your
your
Honor,
signature.
Objection, the document's not in evidence. That's not her Exhibit A or B.
No, it's your exhibit, but that's his signature on the papers that I got served with.
Your Honor,
I,
what she's asking my client is not an exhibit.
This is not your signature.
okay, you all can move on to the next question, Ms. Shea. I sustain the objection.
And I did not. Why?
What was the question, Ms. Shea?
I don't have any right at the moment, Your Honor.
Okay. All right, Miss Isabel, do you have any questions?
No, ma'am.
Okay. Attorney Williamson?
We rest.
All right. Ms. Shea, this is your opportunity to call any witnesses or give any testimony.
I didn't know we were allowed to have those today.
At this stage, the judge carefully walks Ms. Shea through the legal timeline. The case was dismissed in 2019. 2 years later, an amended petition and proposed order were filed anyway. That order was signed, despite no live case existing. The judge emphasizes that even a lack of knowledge does not restore jurisdiction. Courts are bound by law, not fairness perceptions. Without jurisdiction, the judge explains, she legally cannot maintain the order. This explanation is calm but firm, underscoring that judicial authority has limits, even when outcomes feel uncomfortable or confusing to those involved.
I thought it was just us. I didn't know I was going to have witnesses.
Well, it's not required, but if you wanted to have witnesses, this would be your opportunity to do so.
Like a witness, like saying that, his signature was not forged, that it was actually his signature on the paper I put in for Exhibit A.
Well, not necessarily, because remember, this motion hearing is not about what took place at the hearing, if he signed it or anything like that. It's a matter of, was he notified of any amended petition? And according to his testimony, he's saying that he wasn't and he didn't sign anything.
Well, none of us were presented with the exhibits of compliances.
Okay. Is there anything further?
No.
Miss Isabel,
Yes, ma'am.
Attorney Williamson, is there anything further?
No, Your Honor.
Okay. So the court is going to make a finding that at the time that the proposed order was signed, the court did not have jurisdiction
The hearing shifts as the father is called to testify. His attorney introduces exhibits methodically, focusing on signatures, service, and notice. The father states clearly that he was never served, never appeared, never signed a waiver, and never signed the disputed order. A handwriting expert's opinion is referenced, stating the signature on the order was forged. Objections are raised and ruled on, but the testimony stands. This section reinforces the procedural theme of the case: documentation matters. Courts rely on records, signatures, and service, not assumptions or informal understandings.
And assign it, considering that there was no case open at the time. The case had already been dismissed by the court. So any order that's signed by a court, once a court has lost jurisdiction, is a void judgment. So the court is finding that the judgment is void, and I've signed the order to vacate the judgment.
May we get a copy of that?
Yes, I'm actually sending it out right now to the clerk and my coordinator will forward all of you a copy.
All right. And now that that order is void, it has no effect. I'd like just to admonish the parties to act accordingly, please.
Correct. There is, I don't even see an underlying order.
There's not.
Yeah. So there is not an underlying order. If you all decide at some point in the future that you would like to come back and put something in place, we will entertain it at that time. But as of right now, there is no order that exists between the parties.
Okay, so on the child in question,
Yes, ma'am.
is she able to stay here with me until we get this all settled?
That is a great.
Because Mr. Shea just
Yes, I would like to know that too.
Mr. Shea said he's leaving.
When Ms. Shea cross-examines the father, confusion intensifies. She references documents she believes show a different signature, but those documents are not admitted as evidence. Objections are sustained again. The judge intervenes to keep the hearing focused on jurisdiction, not disputed memories or paperwork outside the record. Importantly, the judge clarifies that even signature disputes are secondary. The core issue remains unchanged: whether the father was notified of amended pleadings and whether the court had authority to issue the order at all. The procedural boundaries of the hearing are firmly enforced.
In town next week. He's leaving for a week. He told my spouse that.
Okay, I muted you because I'm speaking and you're speaking over me. As of right now, without a court order, the only people that are allowed to have possession of the child are the parents. Without a court order, it is the parents. So this child needs to go back to her parents until a court order allows someone to do something different. If anyone is in possession of a child that they do not have a legal right to be in possession of, that is kidnapping. You cannot have a child that an order does not limit either of the parents from having that child. So she needs to be turned over.
Thank you, Your Honor.
Thank you all. You have a good
Thank you.